Good evening and welcome to the Modise Network. Tonight, former chairman of the General Council of the Bar, Advocate Vuyani Ngalwana, questions the rate of transformation within the legal fraternity and says racism is still alive and kicking. Later on, Statistician General of South Africa, Risenga Maluleka, joins me on the couch to explain the state of South Africa through evidence research in order to inform policy choices. I'm Tim Modise, and thank you for joining me this evening. And please join the network in conversation through comments or questions on Twitter, the hashtag the Modise Network. The decision by the General Council of the Bar to ask the courts to remove advocates Nomgcobo Jiba and Lawrence Mukhwebi from the role of advocates was rejected by the Supreme Court of Appeal recently. The two advocates were accused by their colleagues of compromising the image of their profession by allegedly protecting the former crime intelligence chief Richard Mdluli from prosecution. The advocates Jiba and Mukhwebi are senior officials within the National Prosecution Authority, or the NPA. The former chairperson of the bar is Senior Counsel Vuyani Ngalwana, and he disagrees with his organization to debar the two. In articles he has written, he argues that the motives to remove Jiba and Mukhwebi could be informed by the reluctance amongst members to transform the legal profession. He joins me on the program, and we are going to have a very interesting chat with Senior Counsel Vuyani Ngalwana. And pleasure to have you with us, sir. Thank you.
Thank you, Tim. I'm sorry I couldn't join you on the couch. I had some business to attend to here in Cape Town.
Sure,
but it's great to be on the program.
We appreciate that. And you feel very strongly. I've followed your comments on social media and the articles that you have written, and I felt that let's have this conversation with you. Why do you think that the decision by the members of the General Council of the Bar to appeal that decision by the SCA is wrong?
Well, let me start off by making it absolutely clear that my view has nothing to do with the merits of the case. In other words, this is not about whether or not Advocate Jiba and Advocate Mukhwebi are fit and proper persons to continue on the role of advocates and to practice as advocates. It has everything to do with the role that the GCB plays in matters of this sort. Now, you will have heard this Latin term called custos morum when reading the articles written by myself and the current chairperson of the General Council of the Bar. Effectively, custos morum talks about, or it's a reference to the bar being the custodian of the morals of advocates. That's a literal translation from the Latin term, custos morum. Now that I liken, for example, to yet another Latin concept called the friends of the court, curia, which is the friend of the court, right? Amicus curiae. The role of both is to assist the court in arriving at a proper decision based on the facts and the law. So in other words, what the GCB should do as custos morum is to place all the facts before the court, and it's the High Court that has the discretion to decide whether or not to strike off a member or to suspend the member from being an advocate. So the bar places those facts, applies those facts to the applicable law, and then leaves it to the court to exercise its discretion. The GCB did that. It went to the High Court, placed the facts. The High Court ruled as it did. It decided that the bar had made enough case to have the two struck from the roll. In my view, that is where the bar, the General Council of the Bar's role ended as custos morum. But then Advocate Jiba lodged an appeal to the Supreme Court of Appeal. That role continues. In other words, the custos morum role continues in the Supreme Court of Appeal, because what it is doing is to assist the Supreme Court of Appeal to arrive at a correct decision. It is not instigating. In other words, it's not initiating any litigation. It is simply assisting the court. Where I have an objection is where, after the Supreme Court of Appeal has made a decision, let's be clear about this, this is a decision of the Supreme Court of Appeal, not a decision of 3 judges out of 5, because the majority is a decision of the court. So, but be that as it may, where the Supreme Court of Appeal makes a decision, it is not the role of the custos morum to then bring an application for leave to appeal to the Constitutional Court. Because once it does that, it overreaches itself by entering the arena as a principal litigant, and that is not the role of the bar. And I'll give you an example. It has never done this before, ever. There was a judgment of the Supreme Court of Appeal in similar circumstances. I think it was 2012 or 2013, the so-called Gish matter, where a whole number of senior advocates, including 2 senior white advocates, were implicated in dishonest conduct that cost the state millions of rands in so-called rand accident fund cases. The Supreme Court of Appeal there decided not to strike those members down off the roll because it felt a sufficient case hadn't been made out. The General Counsel of the bar didn't bring an application for leave to appeal to the Constitutional Court. Why? The current chairperson says in his response to that question, well, it's because we didn't get advice on prospects of success on appeal. But a custos morum doesn't require advice on prospects of success on appeal. And in any event, advice is exactly that. It is not a decree that you shall bring an application for leave to appeal or else. But it simply advises you whether you've got good prospects or you don't. Now, at the end of the day, the final decision lies with the General Counsel of the bar, and it didn't exercise its custos morum rule at that time. I see these two as not dissimilar cases, but as exactly the same cases. But what I see here, Pratim, is an affront, an attack on black professionals, particularly black lawyers. It is not by accident that you have a political party that is waging a sword of Damocles against these two, and at least against the one of the 2 advocates, arising, as I see it, from a disagreement with one former senior prosecutor who's now a member of a political party, who didn't see eye to eye with this current Deputy National Director of Public Prosecutions, who now sees an opportunity to get back at her. Mm-hmm. I see that as the GCB descending into the political arena and playing a role that the political party would have played. Now, let me tell you just one last thing, Pratim, on this opening segment. The debate at the annual general meeting of the GCB in July of this year was about whether we'll be descending into the political arena or not in engaging in this. And I made it absolutely clear that if the GCB were not to bring this application for leave to appeal to the Constitutional Court, we can rest assured that that is not where the matter will rest, because I am pretty confident that the Democratic Alliance would have brought this application directly to the Constitutional Court. And the rules of the Constitutional Court allow for this to be done, because these issues that are going to be raised there have been dealt with in the lower courts and in the Supreme Court of Appeal. So there would have been room in the interest of justice for this matter to go directly to the Constitutional Court. So not only the DA would have done it, I am absolutely certain that there are numerous other so-called not-for-profit organizations which would have jumped onto the bandwagon. I suspect that they're going to do that now in any event. When the GCB goes to the Constitutional Court, you will have people applying to join as amicus curiae, and there will not be amicus curiae at all, because they will be forcing a particular line.
Sure, and I understand that. And for now, I want you to comment on the role of the media in all of this, because you are also scathing in the way this matter was being covered in the mainstream media. If you can be brief in your response, please.
Yeah, well, very briefly, I'll mention two things. The first is you will find that invariably the argument that is advanced in favor of the two advocates is generally either ignored or it's just a very artificial coverage of it. And focus is more on the strength of the case against them. That has been the typical approach by the media. Secondly, following the judgment of the Supreme Court of Appeal, which, as you now know, decided that the case has not been made out to have these two struck off the roll, a journalist goes on a tirade against the one judge and goes and attacks the judge and not critically analyzing the judgment. Attacks the judge by linking, in fact, the two judges, linking them to relationships with the former president and another one having done a whitewash of the arms deal, which has absolutely nothing to do with the merits of the case. So the media, and I don't want to be seen to be attacking the media unwarrantedly, but sometimes this thing of the media taking refuge behind what they say is in the public interest, which is really another way of saying it's interesting to the public, and whatever other intentions the people behind the reporters have in mind, is troubling.
Okay, well, I will be probing some of
those
these.
are the two short answers I can give to you.
Sure, and I appreciate that. In a moment, I will be picking up on the key issue that you've raised, that you believe that black professionals are under attack from various political bodies, but especially in the legal profession. We'll be looking at the rate of transformation with Advocate Vuyani Ngalwana, who is my guest and talking to me from our Cape Town studios.